Good evening. Welcome, everybody, to tonight's panel on ethical considerations in the practice of New York State Article 81 guardianship law, the petition, and the hearing. I'm Kimberly George, president of Project Guardianship, co-sponsor of tonight's webinar series. This event is the third in a series that began in March of this year. Our first panel was on Article 81 guardianships during COVID-19, perspectives from the bench. The second in June was Article 81 guardianships in New York, a statewide perspective. If you missed those two events, you can watch recordings on Project Guardianship's website. Project Guardianship was founded in 2005 as a program of the Vera Institute of Justice to fill a gap in the justice system that left unprotected a population of largely low-income, aging adults and people living with disabilities and mental illness who lack family and other supports. Since its founding, Project Guardianship has demonstrated that a nonprofit program centered on human dignity can enable people with little resources and support to live more safely and independently while also saving public dollars. Project Guardianship offers a comprehensive model of guardianship with a multidisciplinary team of attorneys, social workers, and finance managers. We specialize in keeping people in their homes and out of institutions, as well as moving people back home. We also have expertise in making end-of-life decisions in accordance with the law and with our clients' wishes. We serve as guardian to clients regardless of their ability to pay, and we have the capacity to provide services to the most complex cases. We also provide research and recommendations for a better guardianship system and advocate for more equitable responses to providing services for people who need protective arrangements. This includes working with partners to find solutions that not only improve guardianships, but also divert people from guardianship whenever possible. We recently partnered with Legal Health, a division of the New York Legal Assistance Group, to create the Coalition to Assist Limited Capacity New Yorkers. By bringing together stakeholders and sharing information, the coalition will identify service gaps and develop practical solutions for an improved guardianship system. So thank you all for being with us tonight. To tell you more about Legal Health and tonight's panel, I would like to introduce both Randy Retkin, Director of Legal Health, and Sheila Zablo, Senior Staff Attorney at Legal Health.
Thank you, Kimberly. I'm Randy Retkin. I'm Director of Legal Health, as Kimberly mentioned, and I'm very excited to be co-moderating this panel tonight with Sheila Zablo, who you'll meet in a second. And let me just tell you a few words about NYLAG and Legal Health. NYLAG provides free legal services to New Yorkers who cannot afford a private attorney. And Legal Health, a division of NYLAG, partners with hospitals and community-based health organizations to provide free on-site legal services to patients needing assistance in a wide variety of legal areas. We currently have 36 hospital and community health partners, and I'm pleased to say we just celebrated our 20th anniversary. In 2020, with funding from the Fan Fox and Leslie R. Samuels Foundation, Legal Health launched a pilot program to provide free representation to Article 81 guardianship hearings in New York City. And we also provide trainings to doctors, nurses, social workers on guardianship and guardianship alternatives. So now about the panel. When my colleagues and I first started discussing the idea for a panel on ethics and guardianship, we quickly realized that there were so many issues we encountered in our own practices that one panel was not sufficient. Therefore, we'll be holding 3 separate panels mirroring mirroring various phases in the life of a guardianship and its impact on the individuals with limited or absent capacity. Tonight, we're focusing on the beginnings of a guardianship, from the time when someone determines a guardianship is needed, all the way to the guardianship hearing itself. And when we conceived of this panel, we were inspired by the ethical issues we struggle with, but we didn't want to spend our time on technical reviews of the ethics rules and relevant statutes governing practice, though those are very important, but rather the deeper and ethical and moral issues that practitioners face and really have time to reflect on in day-to-day practice. In short, what keeps us up at night? So in the preparatory meetings for our panel tonight, with our guests, some themes emerged that will give the questions and our discussion some context and that we hope we can cover in 90 minutes. First, a point that Peter Strauss, one of our panelists, made. Guardianship is unique and that is both beneficent and adversarial. There are not many legal proceedings where that is true. So how do practitioners balance this underlying tension and the tricky situations that might arise out of this inherent conflict? Second, how can we reconcile a proceeding that so concretely eliminates an individual's civil rights with a process that relies at its core on a fundamentally subjective determination of capacity? Third, how do we take away someone's fundamental individual civil rights without the guaranteed right to counsel to protect their interests? And fourth theme, which is simply, when is a bad decision just a bad decision, and when is a bad decision evidence of incapacity? So I hope that gives you some context for tonight's conversation. And now I will introduce Sheila, who has the pleasure of introducing our terrific panel.
Thank you, Randy. Tom Catapano is Assistant General Counsel in the Adult Protective Services, or APS, Litigation and Program Counseling Unit of the Office of Legal Affairs for the New York City Department of Social Services. In that role, he counsels New York City APS on agency initiatives, legal inquiries, and referrals. He also manages OLA staff in representing the APS program in various judicial, administrative, and interdisciplinary forums. Deborah Korzanik is Senior Associate General Counsel of the Mount Sinai Health System. She has practiced in all areas of in-house counsel work and, for a number of years, has specialized in patient care and medical ethical issues. She sits on the ethics committees at all Mount Sinai Health System hospitals. Stuart Sherman is a senior staff attorney with New York Legal Assistance Group's Legal Health Program and holds a master's in public health. He is the founder of Legal Health's Guardianship and Guardianship Alternative Project. Prior to joining Legal Health, he was the executive director of New York State Task Force on Life and the Law, a government task force that studies and makes policy recommendations on issues at the intersection of health, law, and ethics. Peter J. Strauss is senior partner at Piero, Connor & Strauss, headquartered in its New York office. He has practiced trust and estate law since 1961 and has special expertise in the legal problems of aging and persons with disabilities, end-of-life issues, and the capacity of persons with disabilities to execute legal documents with respect to healthcare. Peter is a founding member of the National Academy of Elder Law Attorneys, a fellow of the American Academy of Trust and Estate Counsel, and distinguished adjunct professor of law at the New York Law School, where he teaches elder law and is director of the Guardianship Clinic. Mr. Strauss has been honored by the New York State Bar Association with the 2019 Attorney Professionalism Award, awarded to one attorney in the state each year. Felice Wexler is a principal attorney with the Mental Hygiene Legal Service, First Judicial Department. Since 1999, she has been responsible for administering and supervising all aspects of the agency's MHL Article 81 guardianship practice. I thank all our panelists and the audience for joining us today. And now I turn it back to Randy for our first question.
Great, thanks, Sheila. So this first question we hope will not only answer some questions that we're interested in, but also give the audience some context about your respective roles. And so I direct this first question to Peter and Stu. You both serve as petitioners counsel in guardianship cases. And what is your assessment process when a prospective client walks in the door seeking to petition for guardianship? And how do you choose your clients? Basically, how do you decide what cases to take? And what are the ethical concerns you're already thinking about at that point?
Well, in many cases, the clients choose us, and we have to sort out, I think the threshold question is their claim about the need for a guardian for some family member, next door neighbor, whatever it may be, is valid? Are they just acting out on some personal gripe or family dispute, or is this a real case? And, that involves, I think, some experience. We do I think a preliminary analysis of the facts. I like to see whatever documents there are. I want to know whether or not there is a need within the scope of Article 81. I mean, if the person has advanced directives, they've got powers of attorney, advanced directives done at a time when they had capacity, there may not be a need, and I may say this is not an appropriate guardianship proceeding. I think it also depends on whether I have had some contact previously with the AIP. It's not infrequent that the child who wishes to bring the proceeding is the child of a client who may have seen me at some point. I may have represented this person. And that raises some interesting issues under Rule 1.14 of the Rules of Professional Conduct. That rule is very surprisingly quite broad in the sense that it says that an attorney for a person with diminished capacity can take protective action, and then it goes on to say in, I think, subsection B, including the bringing of a guardianship proceeding, right? Really? The law allows us to bring a guardianship proceeding with respect to our own client? And notice I said with respect to, because I'm trying to capture what Randy said came out in our early discussion. The guardianship proceeding is beneficial and adverse and harmful to a person. So it's not against the person. So I happen to think if I could bring the proceeding myself, then why couldn't I represent the child of the person with whom I could have brought the proceeding? But I think that's not a clear question. So that's a threshold ethical question, aside from whether the case is bona fide. So we do a fair amount of petitioners' work, and I also do a lot of cases where I'm retained by the AIP, which I hope will be another one of your questions later on to me or someone else as to whether can we do that, and if there's court-appointed counsel, how does that all play out? I had this actually in a hearing just a couple of weeks ago, but let me stop. Let Stuart take over.
Stu, do you want to describe your practice at Legal Health?
I'd love to. So our practice is relatively new and unique amongst legal service providers. I think, you mentioned the main ethical tension of something's both beneficent and adversarial. And one of the trepidations we had before starting was the adversarial nature of a guardianship proceeding. By and large, what we do is we try to help our clients protect their rights, protect their interests. And in legal health, we have this arrangement where we're a medical legal partnership. So our referrals and our cases come from the hospitals we work with. And by and large, those are the patients that are being treated in those hospitals. So prior to this practice, the way guardianship would confront us is we'd get referred a client, we'd get referred a patient, and they might not have capacity. And because we were not practicing or even entertaining practicing guardianship, we wouldn't be able to help them. And as I said, it's sort of rare in the legal service world. There was no place to really refer them either. So an individual, even if they had family members that were willing and eager to help, wouldn't be able to access services or benefits that might help them stay in the community and just live a better life. So when we started the practice, we made sure that we had pretty strong protections in place to make sure that what we were doing was only in situations where it's absolutely necessary. One of the things that was a priority for us is if a guardianship alternative was available, that it should be used. And by and large, we've been doing this for about 1.5 years now. Most of the referrals we get, we can find an alternative to guardianship that meets the needs of the clients and their families. However, there are situations where it doesn't. And so what is the process we developed? The first thing is to determine capacity of the individual to see if we believe that they do need a guardian. And in our opinion, there is no alternative available. And that's one of the crux of the sort of ethical arrangement we decided, which is someone cannot be one of our clients if they don't have capacity. So only in those situations do we believe we're able to represent the family. If they have ever previously been our client, we don't believe it's ethical for us to petition for guardianship of them. So the capacity is the first one. Second is the assessment of the petitioner to see if they would be the best person suited and what their interests are. And we want to make sure that if someone is petitioning, that their goal is to also keep someone in the community and to make sure that they have as much rights and freedoms and protections as possible. To that effect, we developed, and maybe get in this a little later, a retainer that fundamentally says we will represent people in a petition only insofar as it is in the best interest of the AIP, and we retain the right to remove ourselves as counsel if it is not. And then, finally, we make sure that there's a prima facie case that's sufficient for the guardianship to go forward. Sort of on the ethical front, I'd say that the three main things that come to mind are, determining who the client is, determining who we owe a duty to, and determining what the nature of that duty is. And I think the process we developed sort of helps us sort this out. We are representing the client, which is the family member. It's something that is adversarial and beneficent. And we are doing so for the best interests of someone. So we feel we have a duty to the AIP, even though they are not our client. And we are looking to make sure that people are, if there is a guardianship, that it is as least restrictive as possible, and that it's fundamentally keeping someone in a least restrictive environment. So with that, I'll let you move on to the next question.
So I was interested, Tom, it was so interesting the other day, you described the APS process of case investigation and the decision to represent. Would you share that with our audience as well?
Sure, my pleasure. I guess the difference with APS is that we are mandated to provide guardianship if certain criteria is there, and that all available possible resources have been exhausted or not available. If the client, if APS has tried to implement services for that client, and for example, like financial management services, home care services, heavy duty cleaning, whatever that client was referred to APS, if those services cannot assist the client, or the client is refusing those services, APS may then bring a referral to my office, Office of Legal Affairs, to ask OLA to assess whether or not there's a need for a guardian here. My office will then, we have a procedure with the various field offices within APS where they will submit a referral, also any supporting documents for that referral, say like bank records, if there's a housing court action involved, there's an eviction involved, housing court documents, any Social Security information, financial records, real property records, that will, anything that APS feels will assist in our determination, they'll provide those records. If they don't provide those records, we may ask for those records later on. We have a team of senior attorneys, about 5 of them. One attorney will review that referral and all the accompanying information that is included in that referral. And then we will present that, they'll make a preliminary determination, and they will present that to what we have roundtables basically, where it's almost like a little mini court where the attorney will make their determination and argue that position. And our attorneys will then question and give the opportunity for that attorney to defend their position, or to change their opinion if other lesser restrictive alternatives could be explored, or if there's information that is needed that we feel is important for us to meet our burden, should we file for the petition. And we also have a supervising attorney who's there as sort of like the, to make sure that the right questions are asked, and that, basically to make sure that if we're going to go forward with the petition, that the correct information is there to meet our burden. And, we have a few attorneys, when I say senior attorneys, they have, varied experiences. They participate in, for example, they participate in the enhanced multidisciplinary teams offered by New York City Elder Abuse Center, where they meet other community-based organizations, other agencies and programs to learn about potentially other means that might be able to assist the APS clients before we go for guardianship, because our goal is always to make sure that the guardianship is the last resort, that we exhausted all their other potential remedies to assist the client, whatever harm that they are facing, before we make the determination to go forward and file that petition. One other thing we like to do also is we like to rotate attorneys in this roundtable team, attorneys that have been to court, to also keep it fresh, to make sure that the attorneys that have been to court and know what judges' preferences are, that they represent that to the team, so we have an idea exactly what our burden is, and what evidence we may need to make sure that should we file, that we have a prima facie case and we are likely to succeed on the merits.
So I just want to quickly say, in response to something that both Stuart and Tom have pointed out, I think we in private practice, as well as those of you who work for government or not-for-profits, have a duty to see in the intake stage whether we are doing the least restrictive alternative. So that then often requires me, at least, to try to visit the AIP and see whether there are other alternatives that I could assist in, perhaps drafting and supervising the execution of advance directives. But that puts me in a very complicated and difficult position, because if I do that, and then I determine there is a lack of capacity, am I now conflicted out from representing the person who initially contacted me? So it's almost like the system, on one hand, encourages me to make that attempt to stay out of the Article 81 world, but puts me at risk of not being able then to carry out the beneficent portion of instituting that proceeding. And for me, that's a great ethical dilemma.
Yeah, it sounds to me from what you're all saying is that you really are very rigorous in your sort of assessing of these cases, and sometimes it overlaps in terms of, actually meeting the client and making an assessment, and then where are you? So I think we'll revisit that theme in 1 second, but I want to just bring in Debbie, because it'd be great to hear about her process for when the hospital that she works with goes, moves for guardianship. So Debbie, if you would like to sort of answer the sort of same, the question, sort of your role at the hospital and circumstances that might lead the hospital to petition for an appointment of an Article 81 guardianship.
Sure, I'd be happy. So as you heard, I oversee the patient care legal issues in our hospital system. And so we don't handle the guardianships in-house, but I'm involved with social work and other clinicians in making judgments about the appropriateness of a guardian, of an Article 81 guardian. However, guardianships are the one area that that social work does not have to go through legal. They can contact outside counsel directly. The senior social workers are very experienced with this. And so they don't all come through our office, but there are many guardianships that don't happen, but I may get consulted on whether or not, it's an appropriate decision to make. So the most common issues in terms of guardianship at the hospital are around refusal of treatment and discharge issues. We obviously always want to get patients home, and most patients prefer to go home. But our obligation is to create a safe discharge for our patients. And sometimes either because they don't have means or they don't have the proper setup, it's not appropriate to send them home. And then, the other institutions that we discharge them to are not necessarily places they want to go. So that is sometimes becomes an issue. But to give you some idea, we have almost 4,000 beds in our whole system. And we had in 2019, we had 28 guardianships in the whole year. And last year it was down to 17, and this year so far we're at 14. So there aren't a lot of these actually going on, and the numbers are dwindling. I gather, I understand from outside counsel that nursing homes are more desperate now to get patients, and they're more willing to take patients without guardians, and then they sometimes go for guardianship themselves once they get to the nursing home. But the main driver are the refusal of treatment and the discharge questions.
Thank you. So,
Well, go ahead, Randy.
no, go, Sheila.
So a related and follow-up question for you, Debbie, and just in general, I don't know if we said it explicitly, but we had the thought to direct questions to certain people, but they're really intended for all of you. So please, anytime you want to share something, please do. But Debbie, one question for you is, I think people often think of their doctors as looking out for them, and sometimes without realizing it, they may even think that might not be limited to medical care, but just that it's their doctor. And there's even, I think, something about the possessive term being used. And so the question for you is, does the adversarial nature that we discussed, even though it is as well beneficent, of a guardianship proceeding ever raise ethical concerns in the context of the hospital seeking for a guardian to be appointed for one of its patients? Is that an issue that sometimes comes up in your work?
I'd have to say not frequently, because I think, again, we don't do it very often, and we're fairly careful to do it when it's really absolutely necessary. I'm not there always with it, have a front row seat in the dynamic between the patient and the clinicians when these decisions are being made. But for the most part, not. I think one issue that does come up, and which is a difficult one, is that often for patients, the unbefriended patient who lack capacity with no one to speak on their behalf, under the Family Healthcare Decisions Act, it allows two physicians to make decisions for patients in this situation. And the question is, it's a really just a temporary solution. And so how long are we going to allow the two physicians to be making medical decisions for a patient without capacity? And at what point does a guardianship become an important next step? And I just had a case today where, we're sort of unclear. I'm waiting to hear back how much time they think this patient has, whether it makes sense to get a guardian, whether there's enough time. It takes at least 4 weeks, and will he last long enough? Does it make sense? He's refusing treatment. Guardians can't override patients, so it's not clearly going to be practical. On the other hand, the clinicians are uncomfortable making decisions for an extended period of time for a patient, even a patient who has no one to speak for them. So those decisions can be difficult. There's a real gray area there, I feel.
And when you bring a guardianship proceeding for purposes of healthcare, does the hospital ever seek powers, personal powers or property powers beyond the medical?
Yes, we often do. We often ask for both. It's very common that we go for sort of the full range of powers, because usually, not always, but this category of patients that lack capacity and have no one to speak for them often have very few assets and financial means, and so we usually ask for full authority.
And so one thing I've been myself trying to figure out what I want my practice to be and what's the best practice is once the decision is made to take a case to represent as petitioner's counsel is the question of, you know, that Debbie and I started talking about which powers to seek. And I'm hoping that some of our petitioners counsel that we have here today can speak about how potentially they balance the immediate needs of the AIP, what one might call foreseeable or reasonably foreseeable powers that might be necessary or beneficial, while also potentially seeking the powers that are preferred by the client, the family member, or whoever the client is. If there's anyone who wishes to speak about
Well, first of all, we do have to do what's directed by the client. So to some extent, you know, unless we want to withdraw and if we can't talk them out of it, we do have an issue there. But for the most part, I try to tailor the powers. For example, if I've got a 90-year-old woman who's got some dementia and there's a need for a guardian, I normally won't put in my petition, you know, military service or something, you know, dealing with that kind of stuff, or perhaps even travel if that's impossible. I try to make it brief. I've taken flack from court clerks sometimes because where are those powers? So, all right. But I deal with it most likely once there's been an adjudication in tailoring the order. So for example, if I'm going to give full financial powers, and I think the testimony supported something less restrictive, I'll put in the order that the AIP can manage a bank account with some perhaps limitations on the amount to be put in his or her hands. So I think there are various ways of doing that. But in the long run, if you've got powers that are unnecessary, to me, it isn't a major ethical question. We ought to be practical, but I don't see it as a major ethical question. And we do run into, you know, difficulty with the judges on occasion. They'll put in their own powers. I mean, it's some stuff is really remarkable at times.
Yeah, I think in our practice, we are always trying to have the least restrictive guardianship in a way, in that we are always looking for a less restrictive alternative. And so for the petitions, we want to make sure that the powers we're seeking are not overly broad and unnecessary. In part, we have a lot of, our clients all have limited resources, limited income. So the needs are very specific for them. And I think we try to tailor it to that. But the goal is always to make sure that we're serving the client and serving what needs, what will be as most helpful to them as, sorry, there's a child crawling up my leg. So that's the goal in how we shape those. I think another thing that Deborah mentioned that's really important is also looking at prognosis, which is perhaps a little medical, but I think it's really important to look on from a medical perspective on, you know, is this capacity a temporary loss or is this indefinite? And I think that really shapes what powers someone might need 1, 5, or even 10 years out. If it's someone that will have a chance of regaining capacity, I don't think we should forever, you know, force them under this guardianship, and that we should try to make it as flexible as possible in that regard.
I have asked for guardianships for a limited period of time if I think that's the kind of situation that we're facing. And I also am very careful getting back to the intake and the decision over who I will represent. If it's a case involving a 20 or 30-year-old child with psychiatric issues, I'm most likely to discourage the family from doing it through Article 81 because it's not going to get them anywhere other than gaining access of information. And if they can convince the patient to sign a HIPAA release or give them a healthcare proxy, I think the system and the community is much better served. And we're very careful about doing that in our office. And I would like to think that most of my clients who I deal with professionally have the same attitude.
Just to, I'm sorry to pick
No,
up
please,
there.
Tom, go ahead.
just pick up what Peter and Stu said about, limited duration guardianships. For APS cases, we've noticed that, the court, and rightfully so, we're limited duration to maybe 6-month or 12-month periods. Many of the APS cases involve some type of immediate risk that has to be resolved. Say like a heavy duty cleaning or financial exploitation, or maybe abuse in the home, where, and this may lead to the question when we talk about temporary guardians later, but APS cases, it's more about the immediate needs and the powers that the guardian needs to have to assist to try to resolve that imminent risk that the client's facing. And with that, you may get a shorter duration guardianship where the guardian comes back and reports to the court to see, what's been done. And maybe then the guardian might say, I need these additional powers after discovering what else may be needed, but they'll report back to the court and ask the court for that, for additional powers down the road.
Yeah. At this point, I'd love to bring Felice into the conversation. Felice, as principal attorney for mental hygiene legal services, you often represent the AIP. And can you talk about your role, and does best interest play a role in your representation? And, if you could comment on some of the remarks that have already been made from your perspective.
Well, if you read the preamble to Article 81, it was the legislative intent of when this statute was enacted to ensure that if a person only needed a small amount of help, they would only get a small amount of help, and vice versa. So I'm kind of shocked to hear about court clerks insisting that, the full panoply of powers be requested at the onset. In my view, everything requested should be substantiated by an allegation in the petition. But to answer your question, if I'm appointed counsel to somebody who is objecting to having a guardian appointed for them, then I take the position that they don't want a guardian, and that's what I do when I go into court. My personal feelings as to whether they may need a guardian are irrelevant in that situation. Capacity is presumed. Rule 1.14, which Peter cited to earlier in paragraph A, talks about the duty of a lawyer to maintain as conventional as possible a relationship with their client, even if that person is alleged to have some kind of mental impairment.
Are there ever situations, though, that that this person is not being, rational, or you just really, but no matter what, you will, even though it's not in their best interest?
If I have a client who has not been determined to be incapacitated, and that person can clearly articulate a position with respect to the appointment of a guardian, I will explain to them what I think the likely consequences are. Should that be the position we take when we go into court? I'll explain other potential options they have. I will tell them what I think is the best course of action in the given circumstances. But at the end of the day, if the person is telling me under no circumstances do I want a guardian, then that's the position I take in court. And, it's up to the finder of fact. It's up to the petitioner to meet their burden of proof. And it's up to the finder of fact to make a decision based on the evidence before the finder of fact.
I absolutely agree with Felice, and I represent AIPs on occasion. And when I start my course, my guardianship clinic at New York Law School, I make them read almost on a weekly basis this incredible case that I call my Bible, a matter of MR, New Jersey Supreme Court, which to me articulates that. And if I just may, and then I'll stop talking, the Jersey Supreme Court said, advocacy that is diluted by excessive concern for the client's best interest would raise troubling questions for attorneys in an adversarial system. And it goes on to spell that out at great length. And I think that's the great ethical question here is, what is court-appointed counsel whether it's MHLS or private attorneys, do they temper their advocacy because they think the person's is at risk? And the Supreme Court in this Jersey case said, unless it's patently and absurd, you must fulfill your advocacy obligation. Now, as a practical matter in the courtroom, there may come a time when you have to stop talking, but as it is on a webinar, so I will do that. But to me, that's the golden rule.
Felice,
Go ahead, Sheila.
Felice, you raised an important issue with respect to medical records. I'm hoping you can raise that again today.
In a contested guardianship proceeding, the rules of evidence apply. So somebody's in a hospital and the hospital sees fit to bring a guardianship. They should not be allowed to incorporate confidential medical information into the petition, or to have people who have a confidential relationship with respect to the AIP to testify, full stop. And, you know, if I see something like that, or, you know, anyone in my agency sees something like that in a petition, we will move to strike it. You know, this is notwithstanding the process that the city undertakes, which, Tom, this is for you. I've always had a problem with, because they will send a doctor to visit and meet with a potential AIP, and they will say to that person, you know, this isn't confidential, and, you know, they will allege in their petition or in the doctor's affirmation that the person understood and waived their right, and in the next breath they say the person's incapacitated. So I, you know, long had a problem with that. But, you know, with respect to institutional petitioners or private petitioners, you know, I've seen any number of, you know, medical records attached, letters from people's doctors, and we will, in a contested proceeding, every single time move to strike that material, and we almost always prevail.
And so do medical records have any role at all in the proceeding? I'm thinking of a circumstance where it's not the petitioner's counsel or petitioners introducing them, or is it your opinion that there's never a role for medical records in the proceeding at all?
Well, I mean, the court evaluator, if the AIP is objecting, you know, to disclosure of medical records, the court evaluator can get an order disclosing medical records to that person, but they have to prove, they can't just ask for it. They can't just say, Judge, you know, I want to look at the medical records. You know, under the statute, they need to demonstrate that they are unable to complete their investigation without looking at medical records. So, you know, there is room for that. As, you know, as counsel for the AIP, if my client's objecting, you know, I'm going to object to the disclosure, you know, on the grounds that it's not necessary. The court generally allows it. But I think quite often in cases where it's alleged that medical records are necessary, there's plenty of anecdotal evidence around that could be used instead without, you know, violating a person's doctor-patient confidentiality.
I think that's absolutely correct. And I think one of the flaws is that very often the court evaluator will call the hospital, say, I'm the court evaluator, I have to do my investigation, I'd like to see the medical records, and they're shown to the court evaluator without a court order. And I think that's wrong. Now, let me just say very quickly, there is a place, because this came up, Randy, in one of the questions a few minutes ago, about medical testimony in Article 81. I've proposed that we have a bifurcated hearing, and that once a determination of capacity has been made by the court, and it is a capacity determination, a lack of capacity, then in the remedies bifurcated portion of the hearing, I would think medical testimony should be and could be allowed to formulate an appropriate care plan. because I think that's where it's appropriate then, once that initial decision has been made. And we ought to change the statute to allow that.
Debbie, do you
I
have
don't know how
thoughts?
Felice would feel about that.
If I could just add that it's important to bear in mind that diagnosis, including psychiatric diagnoses, does not equal incapacity. Even if somebody is obviously mentally ill, that in itself is totally insufficient to prove incapacity. And, I am seeing a lot, not a lot, I'm seeing some law firms who represent usually institutional petitioners put language in the order to show cause, allowing the facility to disclose confidential medical information to the court evaluator before, counsel has had an opportunity to speak to the person to find out whether they're objecting, and not making the CE prove that this is necessary to complete their investigation. I think that's unethical. And as far as your question, Peter, I hadn't really thought about that. I'd really have to give it some consideration before I responded.
Before we move on to sort of, Tom, please
Just
go
one
ahead.
thing, just to
Please.
respond to Felice, and, we've had, I guess, on some cases, in court, debated this about our psychiatrists, when they evaluate APS clients, they do say that, yes, that whatever information they garner could be used in court, but we take it as they are not treating physicians, they are examining physicians, and based on that, there is no physician-patient privilege there, and that they could, provide that information if needed. Now, on certain cases, we've gone, we've battled that, but generally we'll use that. But I will also say that with APS cases, yes, the mental health professional plays a vital role, but we also rely very much on what APS observes and their testimony as well at the hearings.
It's in contemplation of litigation. Shouldn't counsel be present?
Well, there's no counsel. This is prior to any. I wouldn't say it's in contemplation of litigation because we have not made a determination whether that would work for guardianship yet.
I'm just gonna, Debbie, do you want to comment on this part of the conversation?
Yeah, I mean, I'd just say that, I understand the, potential benefit of a bifurcated system makes sense. We, a lot of, not all, obviously, we have patients who would be objecting to a guardian, but a number of our patients are not even, aren't aware or conscious to even, we're in a situation where, often it's the lack of capacity is very clear, and there's not really an issue. And then of course we have psychiatry, some argue that, any patient that refuses any treatment, psychiatry is going to find them to lack capacity. I don't think that's always the case, but obviously that often lines up. But many of our patients, when we do see guardianship, are so compromised that capacity isn't really an issue.
So we're actually, believe it or not, we have 10 minutes left for this part of the panel. And I just wanted to move on a little bit to something that maybe all the panelists could answer, which is, should a hearing ever proceed without the participation or presence of the AIP?
Absolutely not. I find that one of the deficiencies in Article 81, and I've said often, it's a great statute on paper, but flawed in the implementation. I think the statute is very clear and it's morally and ethically correct. The court should see the AIP in person so the court can form its own impression of the condition and needs of the AIP. And I think there's too much waiver based on convenience of the court. I've heard judges say things that are very offensive to me, like, Mr. Strauss, you think I'm going to pack up my court, the reporter, the guy with the gun, and my law clerk, and travel to Upper Westchester County to a hospital to visit this person and lose a whole day in the courtroom handling other cases? I'm going to waive it. And I think that happens too often. I think that's wrong.
Other thoughts on that?
I never waive my client's appearance. I've had clients not show up for court, and, you know, I've asked for adjournments, and I had one client, the court granted me, I think, 3 different adjournments in the case, and this woman just wouldn't have anything to do with me. I knew she didn't want a guardian, but, you know, at the 4th court appearance, the judge said, "Do you want another adjournment?" And I said, "You know, I do. I'll keep trying to get her to come to court, but I'd understand if the court ordered us to proceed." So it happens rarely. I don't like it, but it's going to happen occasionally.
So in all of our conversations, unsurprisingly, COVID and pandemic conditions came up, and a number of you raised very interesting, meaning very thorny issues. And I'm hoping maybe we can hear some more about that. Tom, I'll start with you, just because your issue that you raised was something that happened particularly at the start of the pandemic. And I think you know what I'm referring to. If
Yeah.
not, yes. If maybe you.
Yeah,
can
no,
share that with us.
you know, and this, you know, I was going to answer that other question too, but, you know, I think it had to be adjusted now because, you know, COVID, as far as like having the AIP appear, you know, as petitioner, and I feel as part of our responsibility to, you know, see if guardianship is necessary and provide guardianship, it may fall upon the city to provide transportation to the client for the AIP to go to court, because, you know, I don't, unless there's a temporary guardian appointed or a family member or maybe, or a court evaluator or the court appointed counsel would be willing to go, would be willing to assist bringing the AIP to court. If that doesn't happen, you know, we are the last resort, and we have made, you know, we have sometimes gone to where the caseworker will bring the AIP to court. Now with COVID and having the ability, the AIP having the ability to actually participate in a virtual hearing, that's created some issues as well, where you know, the court may look upon the city again to, you know, provide, you know, that the client, I'm sorry, the AIP has a means to actually go on Teams. I think at first the court was using Zoom, now it's using Teams to actually have the AIP participate. But that creates some issues for us because, you know, to us, you know, we would always ask if there's a temporary guardian that could maybe do this, or if there was a court evaluator or court appointed counsel that could help assist the AIP in going on Teams to join in the proceeding. But if that's not available, then again, it falls upon, you know, APS as petitioner to do that. But then we have to weigh to see whether or not, you know, the safety of the AIP, you know, if a caseworker goes in to assist, can that, you know, impact the health of the AIP, or could it also be, you know, detrimental to the safety of the caseworker? Not only with COVID, but say there's a exploiter or potential person in the home that's going to interfere or retaliate against the caseworker. We have to consider that as well. So, you know, there have been cases, especially early on last year, where we had to make that determination whether or not it was safe for the APS worker to go to actually assist the, you know, to provide maybe even the phone or, you know, some type of technical device, whatever that the client, I'm sorry, the AIP could use to actually participate in a virtual hearing. But if we felt that it wasn't safe, either for the AIP or for the worker, we would have to notify the court that we couldn't do that. But it did create a lot of, you know, challenges, and it still does, but to a lesser extent. And I don't know why that's the case. Maybe it's just people now are just more used to, you know, being on Zoom, or just, I don't know, but, or being, you know, doing virtual hearings, or just, you know, operating remotely. But it certainly created some problems for us early on during the pandemic.
Stu, would
I
you?
don't object in theory to remote hearings and to the technology, but I think the judges are a little bit too quick to say it was all rosy. I don't understand how you can have a constitutionally sound system when your court-appointed counsel or your retained counsel can't be with you during the hearing. No remote program can provide for whispering in your client's ear and taking your client aside and allowing that person to get an explanation about what's going on and make decisions at the time of the hearing, which often happens. And I'm concerned that in the movement to accept technology going forward, once we get out of the COVID years, and it may be years, we have to deal with that question of satisfying constitutional requirements. I'm not so sure that that always happened over the last 18 months.
Stu, would you
I'm
like
gonna
to
echo.
share?
Stuart?
What,
Sorry,
Stuart?
I was leaving
I
it
was
to you,
gonna
but
echo-
maybe
yeah.
with the same thing you wanted to say. So go ahead.
Okay, so yeah, I was going to echo what Peter said, and in that I have had growing concerns about technology in our intake process and also in the hearing process as limiting the ability to accurately assess capacity, and this applies beyond just guardianship. It's also in advanced planning, in powers of attorney, in any document that requires capacity in which we're talking with someone. The reliance on this video technology as the sole indicator of whether someone does or doesn't have capacity, because I think there's a lot of things that's missed when you're using it. And part of it might be there's situations or elements that you're leaving out, but also people might, if they have diminished but not fully absent capacity, difficulty with the technology itself. So if you're talking to an individual who is not used to Zoom, and this is the first time they're using Zoom, are you accurately getting a sense of whether they understand or can make decisions? Or are you getting a sense of whether they know what Zoom is? Earlier I stumbled a little bit.
That's a good capacity test.
I mean, it was I had my daughter was climbing up my leg and screaming. My capacity might have been questioned at a certain moment because of something like that going on off the screen. So I think there's too much of a rush in certain important judgments to use technology when actual person-to-person interactions are still needed at that level to fully understand what their level of capacity is and whether this medium is what's impacting it.
We often say that sometimes somebody might be better in the morning in terms of their capacity or clearer, and we'll meet them again at another time or another day. But with technology, it's so difficult to arrange. I wonder if that's falling by the wayside as well. The second chance, if you will.
And there have also been studies that show that people who have cognitive impairments, particularly dementia, they can't relate to a small two-dimensional screen. They don't get it. Whereas they would probably be able, or it's possible that they would be able to have a more meaningful conversation or interview with a person standing in front of them.
And what are you going to do in your middle of a hearing and the AIP's iPad goes blank because the battery stopped? And the judge says, yeah, or my iPad. And the judge says, okay, you got 10 minutes. The 10 minutes comes by and it isn't fixed. And the judge may say, because I've seen this happen, well, we're going to proceed anyway. I mean, we got to think about this and come up with guidelines. And I don't see anybody doing that.
So I just want to point out the other side of this, which and everything everyone's saying, I totally agree with. But I know that outside counsel has told us with our mental hygiene hearings that often it's very beneficial that you don't have to transport patients. They sometimes get very agitated, and that it's a calmer environment when they set up sort of a courtroom in the hospital with Zoom. I know, and this isn't the category of patients or people we're talking about now, but I know, like in the state of Michigan, for child custody cases where children are testifying, or anytime children are testifying, they find they're much more forthcoming on the screen because they find the in-person court so intimidating that they're now moving to have all of them, for children on Zoom. because they're, used to that technology. They're much more comfortable and much more forthcoming. So it's interesting. I think it cuts both ways depending on the circumstances.
How did it work, Debbie, earlier in the pandemic? For example, if AIP counsel or a court evaluator wanted to speak with patients, did any of them come in person? Did the hospital arrange Zoom meetings between counsel and patients at the hospital?
There was very little, outside visitors permitted in the height of COVID. So very little was going on in person. There's always an effort to accommodate in person, and now things, it's not perfect, but have opened up quite a bit. Felice might be able to speak to that more in terms of how much access they've had, but I know the effort is always to have as much in-person access as possible, but certainly during a lot of COVID, that was just not possible. We weren't even allowing, families to visit patients, let alone lawyers having in-person meetings, but we certainly want to go in that direction.
Yeah, there wasn't, we were not seeing clients in person for a very long time. Facilities had different levels of success in terms of obtaining and using technology to help us see patients. But there's at least one or two facilities where the Wi-Fi was so poor that it was almost impossible. So it was a big problem.
My law school clinic is not running the field work portion this spring at 22 because they're still not allowing students to go out and visit patients in nursing homes or at home. And it's not the same teaching experience without the field work portion. We're just doing the seminar. So it's still a serious problem. And I agree with Debbie. We have to be very fact specific. It is troubling and there are safety risks, but we have to balance it. And I don't think we're there yet.
No, it's at this point, I think we have probably a lot of audience questions because we have over 115 people, at least on this panel tonight or observing. So with that, I'd like to let the audience ask some questions. And John Holt will moderate that portion.
Randy, and yes, there are a lot of excellent questions from the audience. Hopefully we'll be able to get to a number of them. I'm going to jump right in. Felice, I'm going to pose the first question to you. What do you do if you're appointed as counsel for an AIP who refuses to speak with you? And do you assume that the position of that AIP is in opposition to the petition?
Yes, I do. Because refusing to speak to me is not the equivalent of consenting to a guardianship. So I would, unless somebody tells me they're consenting, I assume that they're opposed. And if somebody doesn't speak to you, you make every effort possible. The person I referred to earlier who didn't show up for court, she wouldn't return my phone calls. I sent her letters. She mailed them back to me. I went to her apartment on 3 different occasions and I could hear her inside and she wouldn't open the door. So, she didn't give me much ammunition to help her, but, I went into court and I made the best case I could that, she shouldn't have a guardian appointed. Sometimes you just don't have a lot to work with.
Great. This next question, I think, is for those of you who do work representing petitioners. And the question is, in cases where there is an overlap between Article 81 of the Mental Hygiene Law and Article 17A of the Circuits Court Procedure Act, how do you choose which is the right tool to use for the AIP? And how much does the different standards in those 2 statutes play into advising your client and representing them in those proceedings?
Well, I don't like 17A. I understand why people use it. It's simpler, faster, but it denies people rights. I'm a lover of the writings of Kristen Booth Glenn and always have been. And I prefer to do an Article 81, even though it may be more difficult for me. I feel that's part of my obligation as an attorney to be in a forum where I have someone like Felice who puts my feet to the fire. I'm not a litigator by training, and I don't do a lot of court work, but when we structure a case, that we prefer to Article 81. First of all, I think we can tailor it more. I just think in the long run, it's better for everybody. So that's my view. Article 17A, I mean, there's a lot of talk about merging it into 81 and giving more protections in 17As, and I think that has to happen.
So this question's
like you
actually
want to
come up a
respond?
lot. Oh.
Sorry.
This
ahead.
has come up a lot in our clinic and our practice, because prior to starting in 81 practice, Legal Health had done 17A petitions for some time, and with concerns because of the lack of protections and civil rights, and the fact that it's such a medical proceeding that can't be tailored for individuals. But I think one thing that we confront on an ethical basis is limited resources in terms of legal services. And it's almost like in the medical field, you have something, the crisis standard of care, which is when there are so few resources, what is the standard you choose? And so we would proceed and assist with 17A when it was the clear lack of capacity. But as we've adopted and started using 81s, we've started to, and at this point, we're actually contemplating trying to use more 81s and narrowly tailoring them in situations where we would have previously petitioned under 17A. And I think it's because of all the civil rights concerns and the lack of representation, and the fact that it's easy, and that's why it was so great for our clients, especially when it was necessary. But there are drawbacks with that. So I think there's a balance, and and we're developing. I said we're only a year and a half in. It's something we'd like to start exploring more. Is utilizing 81 where previously 17A may have been considered the only option. And also, we've done, our organization's done some work with Judge Glenn, and there's this presumption that people that have intellectual developmental disabilities need a guardian. And we see this a lot, in which, we asked why a parent or someone, why are you thinking of petitioning for guardian for this individual? And they say, oh, this facility told us we need it, or this place said we need guardianship. And, once we talk to them, we explore, one, the person might actually be able to do a power of attorney, or guardianship might not even be needed. So I think that more care needs to be given to this differentiation. And I think there needs to be reforms in 17A as well.
Which I think brings us back to the capacity question. I mean, I think there are a lot of people, clients come in and they say, my dad has Alzheimer's disease, we got to do a guardianship. And after we talk, I say, you know what, let's go visit him. And I may come away with a power of attorney and a healthcare policy. I mean, the people are so uneducated about what capacity really means. And it's harder in the psychiatric world, I think, because, and there I need help. I won't make those determinations.
And I will say with the city, even though we have the statutory ability to file 17A, all of our applications are Article 81. Our community guardian vendors are, under contract for Article 81 cases, and we've actually had a couple of cases where we had to convert 17A to Article 81, which is not easy, but to have a community guardian appointed when a 17A guardian wasn't fulfilling their responsibilities.
I want to pose a question about another tool that's sometimes used by the courts that was touched a little bit in some of the responses from the panel, which is the use of temporary guardianships, especially temporary guardianships that arise at a very early stage in the proceeding based off of the petition and allegations contained therein. How do people feel about the use of temporary guardians during the pendency of the guardianship proceeding? And what do you see as the role of a temporary guardian who may gather a lot of information and insight into the person's level of capacity that may come to bear in the guardianship proceeding itself?
Well, there's two different questions there. I think during the COVID period, it was critical that we had that tool. I did apply for temporary guardians in several cases because, I mean, one order I actually got, we had a motion heard at noon and the courts were closing at 1 o'clock on March 17th. And there was one judge left in the courtroom and he signed the temporary guardianship order. And it was critical because we couldn't have a hearing for months. So I think we got to put that aside. I think they have a place and they may be useful. I think the second part of the question may be more complicated. To remind me what was the second part?
Basically, when a temporary guardian has been involved in a case.
The evidentiary question. I don't know. I've never thought about that. I mean, is that confidential information, or could the temporary guardian testify in order to get a permanent guardian appointed? My instinct tells me that's troubling. Where's the court evaluator? I mean, is the court evaluator out at that point? I mean, I've had court evaluators say once there's a decision to appoint a guardian, I'm finished. I don't have anything more to do. And yet there may be ongoing issues that I think could use some entity like a court evaluator. And I'd have to think about it, but I'd be troubled about the temporary guardian now becoming a witness.
I think that, well, certainly pre-COVID, and I do understand why, you know, during lockdown, it may have been more important or more appropriate to appoint a temporary guardian, but I think it's overused. And I think that the powers requested are overbroad quite frequently. And I find this very problematic because there hasn't been any due process. You know, there are allegations. Whenever I have an intern, one thing I drill into them is pleadings aren't proof. You know, there could be very troubling allegations, but they're just allegations at that point. And based on that, you know, without the input of a CE who can maybe ascertain what the petitioner's motivations are, I have a big problem with the appointment of a temporary guardian, especially with broad powers. And, you know, with respect to the temporary guardian's role in the hearing, you know, we have judges who want them to report. I don't think that's their job. I don't think it's appropriate. I think that's the role of the CE. At that point, you know, the temporary guardian could even have a conflict of interest, you know, in a case where, let's say the person, you know, has a lot of money, might be in their interest to make a stronger case for guardianship.
Maybe we should have a rule that a temporary guardian can't become a permanent guardian, just like we say about court evaluators.
Debbie, I think you were going to respond as well.
Yeah, in the hospital context, you know, we use very infrequently guardian ad litems, temporary guardians for purposes of treatment over objection in a non-psych setting. We do them, you know, courts are not where you want these decisions to be made, but in rare circumstances where, you know, it's a life or death situation, patient either, you know, is refusing or, you know, just it lacks any capacity at all. And, you know, it's a significant treatment. We, you know, go to court and get, because you can, you know, it's much faster. You can get it in a couple of days in order to treat somebody. You know, it's often a situation where it's life-saving and the patient doesn't understand, you know, what's going on at all. So, but those are rare, but we do occasionally do those.
Yeah, we have a comment and a question here about the role of the court evaluator in the court evaluator's report that I think is interesting, and it reads, I'm troubled by the court evaluator's reports and testimony. They are often replete with hearsay, rumors, confidential information, but my objections to such hearings at hearings are generally overruled. What are your opinions on this, on court evaluator reports and their role in the hearing?
Filled with hearsay. There's a great case, I recall it as Judge Luft from Long Island, I don't know if it was Suffolk or not. We've dealt extensively with the court evaluator's report, and I recall that Justice Luft concluded that you could have a lot of hearsay in the court evaluator's report unless it was totally unreliable. The court evaluator had to testify, had to be subject to cross-examination, but that it was often necessary. That's understandable, but it's troubling because there's a lot of medical testimony that is in those reports that should be not permitted. They don't often stick to the functional goals of New York's Article 81 as opposed to a medical model. But the courts have the power to waive it. And I recall Justice Luft's opinion laid out some ground rules. On the other hand, I had a hearing 2 weeks ago where Justice Rosado commented at the end, as she was making her decision, that you can't have court evaluators support a weak petitioner's case. I was kind of blown away by that because I'd never heard a judge say that. But if Justice Rosado is correct, that if the petitioner's case doesn't meet the clear and convincing evidence standard, the court evaluator's report can't substitute for that evidence. I'm not going to comment whether I agree with her or not, but it's an interesting approach. And I don't know whether any other justices have adopted that, but that would be a dramatic distinction from Justice Luft's decision of a few years ago. Felice?
Well, I was, sorry, not quite technical difficulties, but the feline equivalent thereof.
Yeah, I see you putting your fur coat on. Yes.
You know, with respect to a weak petition, I mean, the judges, the courts shouldn't be signing those applications. I mean, I know, you know, they do, but you know, if I'm counseling a case like that, I move for it to be dismissed for failure to state a prima facie case. And I think that as a rule, you know, if the court is going to sign a weak petition anyway, they have to appoint counsel. You know, if the allegations are so vague that you can't even really ascertain, you know, she's incapacitated because she's incapacitated. If the court's going to go ahead and sign that, then they should appoint counsel so that, you know, counsel can deal with it.
Well, my position has been we should have mandatory counsel in every case. I've always taken that position. And my colleagues say to me, I think I'm in the 5% that take that position among the elder law bar. My colleagues say to me, well, what do you need counsel for in a plain vanilla case? And my answer is, that's the kind of case where we really need counsel, because everyone else ganging up on this AIP.
Yeah, and that, I mean, that makes me crazy. The cases where it's obvious. I mean, there's a reason why there's a very well thought out statute to deal with the allegation that someone's incapacitated, you know, and it may be obvious to the whole rest of the world, but that person is facing a loss of their autonomy and is entitled to due process of the law, period.
We have time for at least one more question, and this one speaks to an issue that's come up a few times, which I think is the ability of Article 81 as a tool to address incapacity that flows from mental illness and untreated mental illness specifically. And the question is really, if you are somebody who is considering representing a potential petitioner and the alleged incapacity is really the result of somebody's medication noncompliance, and you know that Article 81 does not empower a guardian to force a person to take medication, what is the role of the petitioner's counsel in advising the potential petitioner about the limits of Article 81, and how do you navigate the difficulties of applying Article 81 to issues of mental illness?
Well, I guess I'm the one that has to address this because my client base is different from Stuart's. I've had many clients come to me with significant means, who have children who have severe psychiatric issues. They've been in and out of psych wards. They stop taking the medication. They're compliant for 60 days or whatever, and then they stop. And it keeps going on. So they want to do an Article 81. And I make it very clear. You can't hospitalize them without going through Article 9. You can't treat them over objection. You can't get a doctor to inject medication in their arms. You can't do that. All you can do, I'm sorry, I'm trying to stop this call. They can get medical records, they can get information. And maybe we got to find a way to deal with that question, because they're an important part of the treatment plan and they ought to be able to know what's going on. I understand the privacy rules and I'm generally in favor of them. But most of them walk out saying, you're right, I'm not going to spend $20,000 or $25,000 or whatever it's going to take, depending on who counsel is, and not get the result that's going to really help you. So if they want to go ahead so they can get access and get information and overcome the confidentiality rules, I'll do it. But as long as they understand, that's about all they're going to get.
Debbie, I'm curious, this is a dynamic you've seen for potential AIPs who are already in a clinical setting, and something that you've had to navigate?
Yeah, I mean, there's no easy answer to this. I mean, we would not be recommending guardianship in those circumstances. You'd be making lots of sort of clinical efforts and, bringing other kinds of resources to bear on, trying to get compliance with medication. But I agree, if, you can't, guardians aren't going to be able to override unwilling patients with or without capacity. So it's not usually a viable option.
In the other statute, I'm blocking the name now. It's not Amy's law, but what is it?
Kendra's law.
Kendra's law, right?
Kendra's law.
There is another state that has an Amy's law. I mean, I tell them about those options. Maybe, you got to keep trying calling 911 and the mobile crisis and try to get people hospitalized, and hopefully this will end. That's not very hopeful in most cases.
Tom, how often does that factor into the kind of decision making you were describing for the attorneys presenting potential cases for APS to petition on?
It's a very difficult scenario when we do face those type of cases that our attorneys try to make a decision, because you'll see that chronic hospitalization, there's a pattern, but it will also manifest itself into like maybe an eviction. So what do? That the guardian can't really have the power to resolve that, what's causing the result. But then again, though, there is an eviction or some other issue, harm that the client is facing, that a guardian could at least resolve that, immediate issue. So it's very difficult, and we take it on a case by case basis. And on occasions where we have filed, a judge may say, have you tried an Article 9? Is this ripe for guardianship? And it's something that, we would say maybe an Article 9 could address like an acute issue, but the long-term problem, we don't know, whether or not a guardian can really resolve that, other than what a manifestation could be as far as an eviction or some other problem that a guardian could address.
But that raises another ethical question for all of us, both you, Tom, and us in private practice. Article 81 is often used as a way to hold off an eviction. And I'm not so sure that's really what Article 81 was designed to do. We all know that these people it's going to end at some point. There's going to be an eviction. We got to solve the housing problem rather than making this an Article 81 issue.
Well, it's certainly, that's also an issue we face with, can we relocate somebody? We would ask for a TRO for a stay with eviction, but we understand that as well, that, relocation maybe just be a minor issue, but long-term, is it really helping the client? Because that client could face eviction again, so.
I mean, you'd be amazed at the number of calls I get from landlord tenant lawyers wanting to have me do an Article 81,
Mhm.
you know, to deal with this and basically relocate the tenant that's not paying the rent. But it's not a capacity issue, it's a financial issue.
So unfortunately, we've reached just about the end of our time this evening, and I just wanted to extend a big thank you to everybody from the coalition who worked very hard in putting this event together, especially Sheila and Randy for your work moderating the panel discussion tonight. I wanted to remind everybody that we do have a upcoming continuation of this series of events on ethical issues and guardianship planned for early winter of 2022. And we'll be focusing on really exploring some of the ethical conundrums that come up after the hearing concludes and a guardian's been appointed. And there's a lot to unpack there, of course. So please be on the lookout for the registration. We'll also be sending a brief survey at the conclusion of the event. And please feel free to give us feedback. It's always helpful for us to think about how to make these panel discussions as enlightening as possible for you as the attendees. Of course, a big thank you to everyone who took time to join us. I hope you found this to be as educational and engaging as I did this evening. And last but not least, a big thank you to our panelists for sharing all of your knowledge and insight into these really difficult issues. It's been really fascinating to hear your opinions about some of these really difficult and thorny issues, and we appreciate your time and all the work you put into doing this and making it such a great event. So thank you, everyone.
Thank you for having us.
Thank you.
Thank you very much.